this panel, which is really going to be focusing on smaller firm compliance considerations. And you know, I've personally worked in very large institutional shops. I've also worked in smaller and mid-sized firms, and I can tell you by far the bigger challenge is the smaller firm environment, because let's face it, you're wearing multiple hats likely. You've got limited resources and access to you know, different systems and everything else that some of the larger firms might have to comply with the same exact rules and regulations. Often at times you might be brought in as a business strategist. You're the risk manager, the compliance officer, you know, sometimes the COO in your firms. We even have a CEO on our panel. So, you know, today what we're really going to be sharing with you is the practical side of what can we do as compliance professionals to address some of the hottest topics that we're facing today in the industry. And so to spearhead this discussion, at the far end of the podium, I have Steve Wilkes. And Steve is a CFA who is also CEO and CCO of Hutchinson Capital Management, which is an investment counseling firm in the San Francisco Bay Area. His responsibilities include overseeing portfolio management and compliance for the firm. He has 8 employees, and the firm's regulatory assets under management is approximately $600 million. Next to him is Scott Drager, who joined R.M.Davis in 2017 after a career serving in senior legal, business, and management roles at the U.S. Securities and Exchange Commission, Citigroup's Corporate and Investment Bank, and as chairman of the Financial Services, Securities, and Asset Management Industry Groups at Bernstein Schur, where he represented asset management firms and institutional investors around the world in a full range of their corporate needs. Now, this is where you're going to have to help me. How many employees do you have?
We have 55 and about $4 billion in assets.
So he
We
has.
still consider ourselves small, though.
For what you're doing, I'm sure you are. Finally, next to me is Sharon Bucafusco, who has been with Tradition Capital Management's LLC's Associate Chief Compliance Officer since 2007. Earlier, Sharon served as the Assistant Vice President at J.P. Morgan Chase in the Investment Banking Division. Her 34-year tenure, but I still swear you're 29. She held positions as a financial analyst, operations manager, product manager, and financial controller in the operations, cash management, and technology divisions. So she's got a ton of experience. She has 20 employees at her firm, and regulatory assets under management are $655 million. So we thought it was important for you to understand and appreciate the demographics of the panel. In the past, I've been in-house at a variety of institutional money manager firms, and the last stomping ground was LPL before going to private practice. So without further ado, we're going to be turning the floor over to Scott. And of course, he has the most exciting portion of the presentation. Why? Okay, the DOL rule was vacated by the Great Fifth Circuit last evening. All right? Now, what that means and what are the considerations for smaller firms, we'll find out, but we're looking forward to hearing your perspective on this.
Sure, thanks, Michelle. I guess I'll start with a little bit of the political backdrop on the issue. The DOL rule, the fiduciary rule, unified fiduciary standard, this is something some of you are aware have been debated in Washington among the regulators and between the SEC and the Hill and the industries for a very long time. We had lobbying on it that was fairly intense back in the late 90s when I was at the commission, and early 2000s tried to start doing something about it, which was when the Chamber of Commerce also started threatening to sue the SEC to overturn any regulations that we might impose. So the politics of what happened yesterday started a long time ago. As Michelle noted, the Fifth Circuit, which is essentially Texas, Louisiana, and Mississippi, those rebels, overturned in its entirety for the Fifth Circuit the DOL rule, which was challenged in court not by individuals or particular firms, but by the Chamber of Commerce and other political players here in Washington. So So for right now, the rule as it stood before yesterday and as expected to be implemented stands across the rest of the country. There is a parallel case that's scheduled to be before the D.C. Circuit pretty soon. It's anticipated that even if there's a concurring view, generally it's unlikely to completely overturn every element of the rule and be distinguished in some particular way. So it's likely headed to the Supreme Court for a decision on what elements of the rule will survive. The politics, why does this matter politically, why does this matter in business, really relate to folks eating each other's lunch and then the cost of arbitration and litigation. So back when the issue of a unified fiduciary standard first started getting newsworthy attention, it related to two segments of the asset management industry and even split off two different views within the RIA community. You had half of the RIA community that said, hey, if the brokers are going to eat my lunch, I want them to play by my rules. I want them to have to be fiduciaries. And then you had another half of the RIA industry that said, hey, no, this is just fine. This is my marketing advantage, saying we are the only fiduciaries. Those other folks don't owe you the same duty that we do. And so even within the RIA community, you didn't necessarily have agreement on whether it would be better to impose a unified fiduciary standard. The reason the Chamber of Commerce is involved is because the brokerage industry mediates and mitigates risk by mandatory arbitration provisions in all their contracts. There's a lot of discussion about whether mandatory arbitration provisions in the construct of FINRA arbitration as a remedy forum is appropriate for fiduciaries. So looking down the road, the brokerage industry said, oh my God, we could be sued and have to be defending ourselves in court rather in this much more manageable forum if we're labeled with this fiduciary role with respect to everything we do. We can't have that. And that's actually what got the ball rolling for involvement of the Chamber of Commerce and some of the other political players. So I always think it's interesting to have an understanding not just of the nuances of all the exceptions to the rule, but why are we here? Why do we care about this from a policy perspective and from a business perspective? The SEC's view, obviously, is that investors have been confused for a long time and about what duty which professional owes to them. So they wanted to attack it for a long time. So that's the politics of the issue. Stay tuned. So much is in flux with respect to what the courts will say about it. So where are we now, putting aside that court decision, for the firms who are in the midst of implementing elements of this DOL rule? Well, financial professionals who advise retirement accounts at a 10,000-foot level under the rule will have to operate as fiduciaries unless you meet certain exemptions, which you are all becoming familiar with, the BIC exemption, best interest contract, or BIC Light, or these other exemptions, which you could frankly drive a Mack truck through. So, so the expectation is that many firms will be able to operate with a variety of fee structures and varying duties to different sets of clients. What most folks who are engaged in the policy side of this issue and where it all might land agree that three things are likely to survive whatever happens in the courts and whatever gets written or rewritten. The first theme that will survive is brokerage industries and advisors will probably continue to be able to utilize most existing compensation arrangements in some form and with certain clients. If they adopt certain anti-conflict policies and procedures along with much more robust and prominent and transparent disclosure about those conflicts. Certain sources of revenue, such as 12B1 fees from particular share classes, are the types of things that might die a slow death in the middle of this. So that if there's one big change that will result, it might be related to those type of fees. So if your firm is like our firm, the DOL rule, as much discussion as it has received, is almost a non-issue. Because, and you may be thinking that to yourself, I suspect, you're already a fiduciary if you're an RIA with respect to all your accounts, ERISA or otherwise. So you probably, as we were thinking, well, how does this really change what we do, or how we treat clients, or the record keeping around retirement accounts? And the true answer was it really doesn't change much at all for those of you who are RIAs, not dual registrants, and primarily serving separately managed accounts. The one exception to that is 401k or employer-sponsored plan rollovers into an IRA that your firm is going to manage. That's the one place where the rule picked up, continues to govern, and likely will be governed in some form going forward, that even before someone technically becomes your contractual client, if they ask you that question, do you think I should roll over my 401k into an IRA that can be more easily managed by your firm, all of a sudden your answer to that question has to be considered in the context of your fiduciary role. That is new. And so I'm going to focus on the one thing that has a practical impact for you, and talk about best practices and what people are doing with respect to rollovers. So the expectation is that when you are in that scenario of having a client who's going to consider a rollover, if they're asking for your advice, that you'll collect information on the existing employer plan and compare that information to what life would be like as a client at your firm. And so the DOL FAQs, which are still good guidance at this moment in time, say that the advisor must make a, quote, diligent and prudent effort to obtain information on the existing plan in the context of providing advice. And the suggestion in the guidance is to develop a checklist to make certain that considerations are discussed with the client that may be material to them. And the IAA has actually done a really nice job, and you can access it on their website for all the IAA members, of putting together a suggested checklist. Our firm drew from that and added certain of its own independent considerations, but that's out there as a great tool, just so everybody knows. And then there's an expectation that you make a record supporting whatever advice that you gave on the rollover, including a record of if you really didn't have a role in giving advice. So if a client just says, hey, I want to roll over this account, folks at your firm are going to play no role in helping them assess that. Maybe they already have 5 or 6 accounts at your firm. This is just a new account that's being added. In that instance, there's technically not a lot you have to do unless you develop a policy encumbering yourself with something to do. So, that's something to consider that I'll talk through and walk through a little later. So there's a handout in your materials for today, and what it does is it draws out a summary of the few suggestions that I think will be helpful to most firms who are in this place of counseling clients on rollovers. And it's bits and pieces that I found most helpful from the IAA's own publication. So the way to protect yourself in this context, here's a few of the things that we do that I had shared with this group. So you get the information on the ERISA plan. That's a pain in the butt. But the SEC's view and the DOL's view both is that, hey, it's publicly available. If your client asks for it, they can get it. If it's not publicly available, then, and so there are laws that require it to be given to the participant in the plan if they ask for it. So whether it's a pain in the butt or not, the view is that it's not beyond your control to see if you can track it down. So talking to the clients about what the alternatives to the rollover are if they leave the money in their current plan, and some of the details that go into this line up in a for or against column. And I'm going to kind of mention how we go through these things. And at first there was an education of the portfolio managers and the portfolio administrators who are on the front lines with this. But it became old hat pretty quick and not too burdensome. So the first thing that can sometimes be a for or against is comparing the fees and expenses the client will pay in the existing plan versus if they roll over and have an IRA managed by your firm, both your fees and the fees that are in the underlying investment products that can be chosen in the plan. You know, if you select only individual securities versus the fund fees that are layered on in the plan, that's something to consider. So if you have, if the 401k plan, what kind of access to investments does it have? Does it have a limited subset of investments versus a broader scope or universe of investments that might be selected if you were managing the account? Some employer-sponsored plans have a trade-link type avenue for going out and buying any individual security. It might be one through Schwab where they're getting $4.95, or it might be one where they have much higher fees to pay on the commission side. Your firm might have, you know, be operating under a $4.95 deal with Schwab. These are the type of things that you'd be noting. Second, the factor that usually enables us to say it made sense to do the rollover is the services that are offered under each option. So there's oftentimes not a lot of financial planning, wealth management, trust, more hand-holding type services available under the employer-sponsored plan as compared to a lot of the RIA firms who are incorporating more wealth management and planning tools into their service. So that may be a reason that weighs in favor of the rollover. Another thing that sometimes weighs in favor of the rollover is a consideration of a client who's desiring to really consolidate all assets in one place. So if they have a number of accounts at your firm, this is the outlier. They really want their portfolio manager to have a full picture of their assets and wealth and to be involved transparently in all that's happening in their universe. That can add to the things in favor of the rollover. And then the things that can sometimes weigh against is with 401ks, sometimes you can withdraw the money a little earlier, between 55 and 59 and a half if you, with certain plans, and you also have certain protections from creditors and legal judgments sometimes in 401ks than you do in the IRA universe. So in a bankruptcy context, you may be in a different place. So at the end of the day, having a checklist, running through these things, it's a pain in the butt at first, but I would say more firms than not have already implemented the IAA's suggested checklist, which is readily available.
Great.
So that would be my, suggestion.
Fabulous. And I know we spent a little bit more time on this topic that was originally anticipated because of its importance, because of what's going on right now. But I want to commend Scott. 1 page of those questions. If you haven't established that checklist, you're looking for training to do with your portfolio management and operations team. I thought this was really well done. So thank you for sharing that with us. I also want to encourage you, if you have any questions, make sure that you could use the app. We have runners in the room if you'd like any kind of comment or question cards. So we're going to transition. Are there any questions on the DOL role? I won't call it new anymore.
Are people, sorry.
No, please.
Are people using these disclosure documents, these standalone? I've seen some brokers use those disclosures, like here, I'm acting in your best interest, and here's this whole list. I mean, I don't like them, but are people doing that?
RIAs are mostly not doing anything like that. The brokerage language that you're referring to is mostly those who are attempting to say the reasons they meet that best interest, BIC exemption, best interest contract exemption, and they're ticking and tying under that element to purport that they get that exemption, but it's less relevant to most RIAs. But what RIAs are doing, and we're looking at this right now, is incorporating something into their contracts that generally disclose to clients in the context of 401k rollovers or any other situations, what they need to know.
And one quick follow-up. I've had some clients want me to put it in their ADV, some blurb. What are your thoughts, Michelle? Anybody about that?
About what to disclose in your ADV?
Well, basically the ADV 2A, like here, the best interest, another kind of a mini blurb of this handout thing I've seen people use.
I've definitely seen that, and I don't necessarily think it's a bad thing. I think what, disclosure generally is a good thing so long as you're actually doing what you are disclosing. And so, I think it's really, up to facts and circumstances for the actual firm, your service model, and what have you to consider. that fair enough? That sound like a lawyerly answer? Yes, ma'am.
What you're talking about here is just rollovers from 401k plans or 403b plans to IRA, not a trustee to trustee transfer from an IRA to another custodian to your IRA, right? It's just 401k or 403b.
That was the scope of what I was talking about, although I would argue for a similar type of analysis under the situation that you just articulated.
Okay. Anything else? All right, we're going to move ahead. The next area that I'm going to be spearheading are aging client considerations. And, you know, similar to Scott, I'm going to give you a 30-second debrief of where we are historically. If you take a look, okay, back in 2014 is where we really started seeing aging client issues emerge. And that's when FINRA and the SEC engaged the National Senior Initiative, whereby they had gone out and examined various firms, and they found out that only 13% of firms had any kind of policy or procedure dealing with diminished capacity issues. So since that time, we have seen aging client issues in the protection of senior investors at the forefront of the SEC's initiatives. And with that, FINRA has embraced a lot of, that energy, and they have, on February 5th, 2018, implemented 2 new rules. And you might say, as an investment advisor, why do I need to know about these FINRA rules? Because they're going to apply to your broker-dealer custodians who have these requirements, which will now affect your day-to-day operations. So the first is FINRA Rule 4512, which is really an amended rule about customer account information. And so at account opening, a member firm, no matter if you're using Schwab, Fidelity, TD Ameritrade, et cetera, okay, they are required to use a reasonable effort to try to obtain trusted contact information. A trusted contact being someone that is known to the client as a trusted individual that the broker-dealer could go to get such information, such as we have concerns that this person might be suffering from financial exploitation, or they might need certain information. They're not unable to reach the client. They don't know who the trustee is. They're trying to get power of attorney. They're not getting a response. They could reach out to the trusted contact. For investment advisors, okay, I know that some of the custodians actually have provided guidance and said that a trusted contact could be the advisor himself or herself. Now, we won't go into, for purpose of this discussion, whether or not you should consider that. I will just say that if you were to elect for yourself to be a trusted contact, certainly there are liability issues attached to that you need to be aware of, okay? But generally speaking, what most advisors are doing at account opening is they're having a conversation with the client, they're trying to obtain this information, they're adding that to the new account form, so you will see in your broker-dealer's forms that they will now have a specific field for you to complete trusted contact information. At the time of the account opening, the broker-dealer will be sending out a written notification letting the client know, regardless if a trusted contact is given or not, that they have the ability to reach out to that trusted contact and to let them know about, for example, any kind of concerns about the client account, like financial exploitation or suffering of diminished capacity, or to obtain information. Your other new rule that went into effect was 2165, and this was brand new. And this is dealing with the financial exploitation of specified adults. Specified adult being defined as someone who is over the age of 65 or someone who is 18 or older who has a mental or physical impairment such that they're unable to protect their own interest at this point. If a firm is under the impression that there is, and we've got concerns of any kind of financial exploitation, what we can do is we can hold the disbursement of client funds for up to 15 days. During that 15-day period, the advisor would be expected to do their own investigation to see is something really occurring. Importantly, within 2 days of placing that hold, you have to provide written notification both to the trusted contact as well as to the client. okay, about that you're holding this. In addition, from the member firm, for the broker-dealer, what they're going to need to do is develop written supervisory procedures on this, conduct training, et cetera. And so, if you think about it, at your firms, we were talking last year about aging client issues and the importance of developing a policy and procedure about how are you going to deal with financial exploitation issues. Now at the forefront is this new rule that goes into effect. And what this means is that if you suspect financial exploitation, part of the protocol could be, I'm going to be contacting my broker-dealer. I need to notify them. I might need to notify law enforcement or adult protective services, and we'll talk about that on the next section. And so think about, do I have that in place? Is it clear to my operations people what the escalation procedures are? And are you aware that the broker-dealer, if they know that you suspect financial exploitation, or they do, they can reach out to the client directly or the trusted contact directly to have this conversation, okay? What they normally will do, and I will tell you procedurally, because I work with a lot of the broker-dealer custodians, they absolutely want the advisors involved if you want to be, but you don't have to be, okay? Yes, ma'am.
I have a question. I mean, they don't have to have a trusted contact. They have to make reasonable efforts.
Correct.
For the client to name somebody, but it could be the client refuses, right?
Right. If the client refuses, and I've had numerous conversations with the broker-dealer custodians, they'll still open the account if you leave that field blank. And here's, we don't have enough time during this panel, but here's the conundrum that a broker-dealer faces. If you think about it, let's just say hypothetically, you're Schwab or TD Ameritrade, and that's their standard. They have to, make sure that they're making reasonable efforts to obtain that. Well, you're their conduit. You're the client-facing person. So that then really rolls down into the advisors. So what they've been really trying to do and to communicate, which I think they've done a pretty good job, is to go out with really the approach of, look, it's really your fiduciary obligation. You're trying to do what's in their best interest. This rule is not about paperwork and trying to add to the burden that you have. It's really about trying to protect the end-all investor. So we need your help. And with that in mind, and if you take that approach, it's a much better conversation with the client than we need you to fill out this additional information. Yes, ma'am.
So we had begun about a year ago to have our clients fill out a trusted contact form for us. And in there, we just, have some disclosure in there that it was up to them to provide us with a new, if that should change, that they're responsible, and we try to do it in client meetings to ask them, has anything changed? But so what's the liability to RIA? If we have that form on file, we provide it to the custodian, and the client hasn't signed off saying yes, we're providing that information. And then again, I would assume then we're liable if it does change, we update our records and we don't tell the custodian.
Right, and so that really becomes communication in books and records. And I think, from the trusted, there's an expectation that the trusted contact information would be updated whenever there is account changes, or, and I think, and I hate to say this, sometimes we live in a dysfunctional world with dysfunctional family members, and they might say, I want this person one day, I want this person the next day. That's just real life. And so as part of the interfacing with your clients, that communication should be happening. And especially if you're having, and I'll open it up to the panel, what they're doing. But I think typically what I've seen is that when they're going to those annual face-to-face client meetings, that's the interface that they're having. Do you agree?
Yeah, that's exactly what we're doing,
Yeah.
Okay.
We have the same thing, is that when we meet with our clients for their annual reviews, not only is it to review their financial situation, but we try to address their holistic situation. What are their retirement, needs? Have their estate planning changed? Have their family situations changed? Because their legal documents, their POAs, their trust documents, those may have all changed as a result of changes in their financial, in their family situations. And therefore, the trusted contacts, as a result, may have changed. So therefore, we try to update it every time we do an annual review, or to confirm that what we have is accurate.
Yeah, our firm, we just started implementing this as part of the ongoing, or the onboarding process, and then also similar for the annual review process. I have a document that we just started to implement where we're getting authorization to provide financial and investment information to third-party members, whether it be family members or another trusted advisor.
Okay. I'm going to hold off on questions only because I'm going to get through this section, then we'll take questions before we segue. With regards to, the state considerations, NASA, that I'm sure you're aware of, they had in 2016, on January 22nd, they had adopted the Senior Safety Act, and that serves as the model rule for protecting seniors as senior investors. And specifically, you can look on this map, okay? There are over 13 states now that have adopted formal legislation in that regard. And it's expected this year that there will be another 10 states added to this list. There's some states that aren't colored and shaded, like the state of Maine, and it's important for you to recognize that even though you might be an SEC registered investment advisor, you still are subject to the rules of these jurisdictions as it relates to senior investors. And so, for example, the state of Maine has a requirement for banks currently that it's mandatory training on how to deal with aging client issues like financial exploitation. It's not yet rolled over to the IA and the BD side, but it's expected. And what NASA's been talking about is really, what should the continuing education requirements be for investment advisors? And so the IAA specifically asked me to just bring this up to your attention, that while there's nothing formal, there is definitely discussion that is occurring at that level. So, it'll be interesting to see, not just on aging client issues, but the whole spectrum of training. This is one of the subject areas where they've really highlighted, though, the importance of this, and that people need to be aware of this as fiduciaries, what we're doing, and that if there is financial exploitation, many of these states have requirements. You have to escalate to Adult Protective Services. You have to notify law enforcement. And so my question to you is, have you thought about that for your own written policies and procedures? Within the handout, we've provided for you some of the very specific things that you should be thinking about and training on what are diminished capacity issues, what are financial exploitation. And, we don't expect you to be a medical doctor and have expertise in this, but these are things that you should make your advisors aware of. And then the question is, if they detect this, how are they documenting that, either in your CRM system or in client notes? So we've provided for you a couple of risk management tips and takeaways with regards to, not just having that policy procedure, but training on it. Think about, how are we documenting client meetings? How are we notating if there's a change and now all of a sudden behavior is becoming atypical? We're going to go through the client notes and files and make sure we know who has authorization on the accounts. And then for client agreements, I am going to hone on this. Think about what you will be doing. There is a certain sample contractual language, if you're a member of the IAA, that they provide in their contracts that gives you guidance and saying, look, in the event that we believe that you're, suffering from diminished capacity or what have you, here's what's going to happen. It's not the same old typical management style. There might be a situation whereby we're not going to automatically take that client instruction, okay, so we can evaluate the situation. So I really want you, it's facts and case circumstances to what your firm is and what's going to be in your servicing model, but it is something for you to consider. And I think, finally, when you're doing, and Sharon's going to be talking about this, when you're onboarding those clients and you're talking about, the need to have this trusted contact information, what a wonderful opportunity for you to have some active dialogue with them about how the client can protect themselves, not just about, from an aging client perspective. The SEC actually gave a whole checklist of, if you're an aging client, here's everything you should do to prepare. Your power of attorney, your trust documents, making sure files in order, making sure that your children are aware of what is going on and where to find these documents in the event something happens. Think about this, but also think about other things that you could be doing, like cybersecurity protections and talking to them about giving, don't give me your social security number. Make sure this is how we're communicating to protect yourself in the world that we live in today. Yes, ma'am.
I have a question. If you're an SEC advisor, and the stuff with the different states, the training that is required, are you governed by the state that you're in or by the state that the client?
The state that the client is in. So, and this becomes your challenge as a smaller firm. Do we have the resources to go out and figure all this stuff out? Now, I will tell you, NASA has done a brilliant job. If you actually go to their website, you can click on the state that your clients are located in and it will bring up the regulations. So they have really tried to make this as easy as possible. And I think that, it's just, we don't know what we don't know. So you've got to constantly be aware and checking this. And I think that could be also, as part of your, quarterly forensics that you're doing in your firm, maybe assign somebody to go and check and see has anything changed on those other states, okay? All right, we're going to be transitioning to portfolio management issues. And, Steve, this is an area where, regardless if clients are aging or otherwise, we constantly have to be taking a look at what are our internal controls. So what have you done in this regard?
Okay, well, I'm going to touch on a couple of things my firm has done. As Michelle alluded to, compliance is just one of the hats I wear, being a relatively small firm. Primarily it's business management and portfolio management are my primary responsibilities. And then our former CCO went back to the SEC as an examiner a couple of years back, so I got the dubious distinction of taking on these additional responsibilities. So a couple of things that just more bread and butter that I think are important to highlight, and this is more from the portfolio management standpoint, but it does touch on compliance. First off, we have client service standards that we've implemented in our firm. And so all of our client-facing, we call them portfolio managers, so they're interacting with the clients primarily. We've set a minimum of at least one face-to-face meeting with every client in the firm. Sometimes in reality that's not always practical because of logistical reasons, or sometimes the clients, it's more pushing them to meet. But one of the things that we've instituted is if a face-to-face meeting isn't practical, to have a proactive call with each client. As fiduciaries here, whether the client is $100,000 or $10 million, we still have that fiduciary responsibility to manage the assets. Most of our portfolio managers are CFA charter holders, and so professional code of standards require that we're checking in with that client on a regular basis and at minimum of 1 year. So if that's, we also have ongoing conference calls and email communication with more and more of our clients. And other things, when we're having the meetings, what are we touching on? In my meetings now, a lot of people are focused, returns have been good the last several years. So more in my conversations have focused on the risk side of the equation and revisiting, asset allocation and the portfolio side of things. But also just taking that holistic approach and going through the estate planning documents, power of attorney, making sure everything is in order. We're not trying to replace the other experts, the estate planning attorney or the accountants, but oftentimes it seems like our firm is charged with collaborating and coordinating those efforts. So just a few practical examples.
How do you standardize the content of that meeting among your portfolio managers?
So we have standard templates that portfolio managers can use. I mean, each client is different, but we want to make sure that portfolio managers are touching on all items. I can share with you offline if you want, just kind of. Yeah, and so that's the important thing I'm getting to here in a second, is just documenting the meetings. Paul Glenn chaired a session yesterday, and I wholeheartedly agree. If it's not documented in the CRM system, essentially it didn't happen. And so we identified some gaps in that area in our annual compliance review, and we just want to make sure that all those client communications were put in place. A couple of other things that have come up just recently is IRA beneficiary forms. There was a client situation recently where the IRA owner, a doctor, his health was deteriorating. His wife was about 15 years younger. It comes to find out we didn't have a power of attorney documentation on file for her. So that ended up happening. It would have been a lot more challenging if he would have been deemed incapacitated. So just trying to be proactive on a lot of these issues that are related to aging of clients. And it seems like oftentimes we as the investment advisor are really the ones charged with coordinating that effort. For our meetings, another thing is we come back with a set of action items from all of those meetings, and then we also are doing that for the clients and have a clear documentation of what they need to follow up with, and that seems to have been things that have been somewhat helpful. So if you could go to the next slide. Along the lines of communication, all of our accounts, we have investment policy guidelines. Again, this is more from the portfolio management vantage point, but we think it's a very important document from a communication tool. Oftentimes my meetings now, they serve as a reminder of what their risk tolerance is and what their return expectations. The last 9 years we've been largely in a bull market, so many people have really forgotten that risk side of the equation. A key component of the investment policy guidelines is the target asset allocation. So again, I have samples of what we use. None of this is going to be earth-shattering or super novel, but again, it's important to get that bread and butter right. And then also, so the other things, return objective, risk tolerance, cash flow needs, time horizon, tax, legal and regulatory, but also unique circumstances. Many of our clients now, we're in the San Francisco Bay Area, so environmental, social type issues often are things that they want to incorporate into their portfolio, so making sure we capture those items in there. And then updating the investment policy guidelines. Again, when we did our annual compliance review a couple of years ago, we saw significant gaps at the extreme. One portfolio manager was getting a new signed investment policy guideline at every meeting, even though if there was no change in asset allocation, just to reconfirm things. And I don't think that's necessarily bad, but when we had other people that essentially had the guidelines in the proposal, but not in a separate document, that raised some concerns for us. So we went back and did an inventory of all of our clients and got new investment policy guidelines where we needed those. And again, we incorporate that with our annual compliance review, the testing of it. Other things just in terms of portfolio management or forensic review. We started doing this a couple of years ago where we're looking at the equity returns. We're skewed towards the equity side. We're about close to 70% equity and 30% fixed income. So we're looking at our equity returns across the firm, and then we're looking at equity returns by portfolio manager and just looking for any dispersions there. And anything beyond one standard deviation, we're going back and digging into that. Again, I have copies of kind of what that looks like if people want to get into more technical details.
Yeah, and I'm just going to pipe in. I can't stress enough. I handle a lot of SEC exams. That last point about the disparity in the client portfolios, I understand you could be doing individual account portfolio management. Not everybody's doing model portfolios, and that's great, okay? The SEC is going to take a look at that. They're looking at dispersion. They're looking at this, and they're saying, what about these opportunities? Did you make this available to everybody? And I really applaud you for doing it. I think that's a great internal control. Now, one of the other big client servicing issues, okay, that is at the forefront of everybody's mind is custody. We know you just came out of a session. We're not going to be rehashing the rule. But we're going to be talking about practically, Sharon, there's obviously lots of challenges in this area. What are some of the things that you're doing and how you're addressing your internal controls around this?
Right. Well, I think with clients, for some clients, we may have those that you only manage their money, right? And that's all that you do. So a lot of it has to do with SLAs and moving their money. In others, such as ourselves, we're a high net worth client, we're a wealth advisor firm, so therefore we also perform other services such as trusteeships, POAs, executor of wills. We sit on boards of some foundations where we have in fact, we saw a president on one of the foundations. So therefore, you now have other areas that you definitely do have custody, so we are under a surprise exam. So you always had the opportunity to choose, do I want a surprise exam, do I want custody? If I don't want a surprise exam, then I don't want to do those types of services. Well, obviously with the new guidance, now with SLOAs, everybody is going to be considered to have custody. All right, so you now, in the new world, since we have that, the first question you have to ask is, how does it impact my firm? You have internal impacts, and then you have external impacts. Internally, let's look at our processes. What do we have to do now? We have clients that had SLOAs, we did wire transfers, et cetera. Maybe we needed signatures, maybe we didn't need signatures. So now your first rule of thumb, I think, is to go back and really look at what are my current active SLOAs that I do have on file. Engage your custodian. They can probably give you this information if they haven't already, and that will help you to see who do I have the SLOA with. Use this as an opportunity to consider if those SLOAs that you already have on file, some of them may be obsolete. So let's get rid of it so that we don't have the conflict with SEC that, well, you say that you have this one LSOA, but guess what? We don't use it anymore, so why do you even have it there? Did you even include it in your custody numbers? Also, so remove those that you don't have. Now put in place those that you have to put in place. Previously, a wire-to-wire transfer for first party could be verbal. That's not the case anymore. You have to have specificity. As everybody knows, you have to have the RT, you have to have the account number, you have to have the bank, and the exact title on the transfer. So make sure you have that in place. In some instances, the custodian has done this stuff for you. There are differences in custodian definitions. Make sure you understand that. What one custodian considers a first party or a third party, the other custodian may not. I spoke with one custodian who said, well, if it goes from an IRA in the name of John Doe to the personal account in the name of John R. Doe, that's a third party. And you're saying, how can that be? It's the same person, but they consider the title itself. They don't look at the tax ID, so therefore, that custodian considers it a third party. Now you have another custodian who says if it goes from a John Doe to a John and Jane Doe, it's still first party. You don't have to have anything in place. But if it goes from John and Jane Doe to John Doe alone, that's now third party. So you need to have something in writing. So really check with your custodians that service your clients, understand what their definitions are.
I would just note, I mean, and there's a really practical reason for that, right? I mean, there are divorces, there are family feuds, there are things where, I mean, you wouldn't necessarily want someone to be able to call up relative to a joint account and move money into an individual account. So I think these are controls that make sense, you know, anyway.
But in order to address now these custody issues, you need to really, though, understand those. And remember, in your ADV, you're going to have to report these assets. So when you get rid of the obsolete ones, you therefore are now reporting directly those that you need to, and you're not having, remember, you can get exemptions under the no action letter, so that if you don't want to have the surprise exam, as long as you have the specificity, you follow the 7 steps that there are to best practices. The advisor is only responsible for item number 6.
And Sharon was kind enough, she gave you as a handout, okay, it's called 7 Conditions to Avoid an Annual Surprise Exam, okay, 1-pager. This is your checklist.
Okay, so number 6 on it is that if you just have to prove that the third party that it's going to is unaffiliated and they are not at your same address. Laura covered all of this in her custody panel that we just had. So when we look at internal, yeah, we have all that. Now, remember, you have your client. That's another concern that you have. It's going to involve, in some cases, working with your client now and changing how you did things for maybe 10, 15, 20 years or 5 years, you may have to get repapering now of some of the transfers you used to make in every day-to-day world. So of course, they're going to come back to you and say, well, why do I have to do this? You know, you've been doing this for me for the past 5 years. What you want to do is not just be, you know, the parent, well, this is how it's done or because I said so. What you really want to be able to say to them is, it is a new regulation, but the new regulation is to protect you as the investor. We want to make sure that your money is moving to the end party that you want it to move to. Okay? Has the address of your child changed? Maybe you don't want to send money to your child anymore, okay? They should be out, they're off my payroll now. So therefore, you're looking to use it as the opportunity to work with them to update. We've had these in place, we've had these 10 in place for you for the past 3 years. Are they still relevant? Let's get rid of those that we don't.
Now, how many of you would like Sharon to come speak to your senior executive team about this approach? It's pretty powerful. Yes, sir, you have a question?
One quick question. In the last session, they said that even if you're exempt under the 7-part test, right, that the SLOA still count as custody.
Yes.
So as far as reporting on the ADV, Michelle, we have, for example, trusts that we, you know, we have the surprise exam regardless because we're trustees. So I have those accounts, those assets listed. Am I also adding in all of the accounts over which you have SLOA?
Yes, you are.
Now, here's another question. We don't really we look at it more in terms of relationships instead of accounts. So most relationships might have 5+ accounts, but only 1 or 2 of them may actually have an SLOA on it. Do you have to parse those out, or?
Yes,
Yes.
yes. Yeah, you have to parse them out.
Fun times.
Yeah.
Yes, ma'am.
So our firm has custody, I think, in every way possible, and it encompasses.
And most do.
Most of you do. Now with this change, you do.
So why not just claim you have custody over all of your client assets and all of the accounts, and then?
It's expensive, the surprise audit. It really
Yeah, the
comes down to
surprise
that.
audit is very expensive.
It's very expensive.
And it also has an impact on your client. Remember, when you do a surprise audit, your auditor that comes in, he's going to get a list from you of everybody that you're a trustee or that you have custody for. They then are going to go out to the clients, because part of their process is to tick and tie what you say you have under custody, what the custodian says they have under custody, and the client has to confirm that I'm in agreement that you have those same assets. So there is an added step there for the client of having to, you know, confirm this. And in some cases, some firms pass on the cost of the surprise exam to the client. So therefore, if they are under now a surprise audit, you're now passing
And
on
that's
additional
typically
cost to
under,
them.
I just want to do the caveat, it's typically under a family office situation where it's expected as, yes.
Right.
I'm going to take 2 more questions in the interest of time. Yes, ma'am, you were next.
I'll just comment that last year we had a surprise exam for a subset of accounts where we truly have custody, like this gentleman here, where we are trustees. This year, or that was in 2016, in 2017, we had a surprise exam for all of our entire account base, and the cost differential was minimal because of sampling. So we're happy with just having a surprise exam with law and everything.
Yeah, I was going to share a similar perspective because, like the gentleman here, originally we just had our trust world, which represented about 15% of our accounts, and then we have personal affairs management service where people have access to essentially check writing privileges over accounts, so we have some custody there. But we expanded the scope relative to some other services, and we didn't notice an appreciable increase in the surprise exam cost. And the portfolio managers were initially very concerned about what Sharon articulated was another hassle for clients to deal with, although we didn't experience that it was much of an issue for clients. So by and large, I would say the fear factor associated with the surprise exam relative to the cost and the actual hassle, you know, it hasn't been that big of a deal. So I would say if you're a firm where you say, you know what, we really, being a trustee or having personal affairs management or having these SLOAs in a manner where we can change the timing and amounts of payments, you know, and things like that, if those are all important services, I kind of feel like it's a tail wagging the dog if you don't provide any of those services to your clients just because you don't want to have the surprise exam. It's not that burdensome. I mean, for us, I'll just share, it costs about $15,000. So I don't know what that feels like on the scale of expenses for you, but it's not catastrophic. Anyway, Laura.
Michelle, there was a case though where a firm just threw up their hands and said, we're going to say we have custody over everything, we can't deal with this. And the SEC said, no, you're skewing our results, our sample sizes, our data. Don't do that. So just be aware.
That's a really important point. I have to stop questions here so we can continue. If you could just quickly walk us through some of the considerations operationally.
Yeah, so as I said, just operationally, just make sure, you make a checklist of who you have the SLOAs on, check with your clients, see if they're needed, see if they're not needed, and explain to them in a nice way. And it may take 1 or 2 or 3 times. Be patient, because some of the clients still don't understand, well, why should I be impacted by this? Because there have been changes in the industry. Okay? And the other thing is make sure you tick and tie to your ADV. Report it under your custody, but you do have the verbiage to say, I have X dollars that I have real direct custody from the standpoint of trusteeship, POAs, executors, et cetera, where I have these amount of assets that are there purely because of the movement of money. But make sure you have all your written documentation to prove that you do only have it. You can classify for the no exaction exemption.
Okay. And what we're going to be doing, just so you know, Sharon really did outline within these slides some of the considerations, for example, for ACH and transfers and things like that. I would encourage you, use that as a checklist, go through that for different considerations of what you want to think about. Importantly, and I think, as we are talking about this is a client servicing service model for your firm. What are you doing? What's going to trigger it? And then what if, then you're going to need to decide, do we want to continue providing this service or not? And that's what I think this is really, that's a business decision for management. So all great points by the panel here, and thank you for your questions. We're going to now turn to the area of performance reporting issues for investors. And Scott, I know you had some thoughts on this area.
Yeah, I'm going to be very quick since we're running out of time. But I also am going to give a shout out to Sanjay's panel yesterday. It was just outstanding on this issue. And I think it's the first time I actually used the app to go on and rate something, but really nice panel. I'm just going to say 2 things. If anyone in your shop is using benchmarks for comparisons of composites or even with clients, even though it may not technically be captured by the advertising rule, you really need to centralize that function. You cannot have a situation, and I saw this in my days of defending exams, but also just in my own shop. You can't have a situation where PMs have the capability to get onto Bloomberg and create, some machination of comparisons of things to whatever benchmark of the day helps for them. That is a road to a fraud allegation, and it is very dangerous. And so I can't caution you enough about how to ring fence that and centralize that. There should be just the CCO who's involved in determining whether the benchmark is an appropriate comparison. And then the other thing is just it really has to be apples to apples, whatever you're showing. And there are so many nuances to that. But by way of example, if you're showing a target allocation of 80-20, and then as a benchmark, and 80% equities, 20% fixed income with some basic benchmarks. And your composite really was kind of 78, percent equities to 22% bonds. That's going to be seen as completely misleading by the staff. The only reason maybe you outperformed is because you overweighted relative to what the target was. So that's one of 100 nuances I could throw out there. Another one is if you're showing your international sleeve comparison to ACWI, how weighted were you in emerging markets or traditional internationals versus what the split is in the ACWI. And you have to identify the ways that it is not apples to apples. You have to disclose prominently the distinction, and you have to disclose the impact it had, positive or negative, relative to the performance of your composite vis-a-vis that benchmark. This was one of the areas where I just consistently saw people doing it wrong. If it looks fishy and smells fishy, then it's fishy. So.
And I'll tell you right now, I have 6 SEC examination response letters that I'm working on with clients, and in every 6 of those letters, there is a performance discrepancy, all of them. And it's so easy to make that, you say, well, we're trying to be reasonable here. We thought this was the right approach, and it's so easy to run afoul of the anti-fraud provisions.
Yeah, and we all have the PMs to say, well, but our strategy really has no benchmark, that's perfect for it. Well, that's okay. You can still use benchmarks. You just have to disclose the ways that they're different and the impact on that benchmark's performance versus your composite. Yes, sure.
Is it okay to just say your benchmark is always the S&P 500 and explain why you're different?
Well, it's okay if you have generally a large cap equity strategy. I mean, I would say I have very rarely seen the staff challenge the use of the S&P 500 in any context. So I think as a practical matter, the probability of the risk is very low. But I think what the staff would still say if they were here is, if it's not an apt comparison to your strategy, then it doesn't make a lot of sense. Because if you're a small cap strategy and you're underperforming all the small cap indexes for the period, but you're outperforming the S&P 500, I would argue the comparison's not very relevant. If somebody could just pick up a small cap index fund instead.
Okay. I'm going to this is going to be rapid fire, last minute. We wanted to leave you with some thoughts on how to do compliance with limited resources. We're going to be 1 minute over. I apologize for that. But I think that these are really, really important. So Steve, could you just, out of this slide, what do you think folks should be focusing on?
Try to leverage technology, and one specific thing we've done in the last year is implement Schwab compliance technologies for personal securities transactions.
Okay, and what about you, Scott?
I would say training, because you really, when you're wearing a lot of hats, you really have to rely on the trust you have with your colleagues, but they can't help you if they haven't been properly trained. So making sure that other people in your firm are kind of the additional eyes and ears and able to spot the issues, I think is really important.
Okay, and Sharon, I'm sorry, my finger went too fast. So you've got a final thought.
I will piggyback on to what the gentleman to my left had said, and that is engage all the other people in your firms. You wear many hats. So therefore, when you get new guidance, engage your business areas, let them help you to develop the new policy, the new processes. They are the ones in the trenches that know best how to do it.
Now, there were a lot of questions, and I want to let you know this panel is available. We will be staying up here until every question is answered. If you want to come up, I'm sorry I'm committing you guys, holding you from lunch, but no, sincerely, thank you so much for attending. We just really appreciate it.